for Qualcomm as Technology Counsel, looking after various IP initiatives at Qualcomm India. I'm also co-chair of IPR committee at ASSOCHAM. This is a webinar series that we have started to connect with you all on the field of intellectual property. Now, as we all know, this is a century of intellectual property. For any country who aims to play a significant role in the global economy, intellectual property plays a crucial role in achieving that goal. Through this webinar series and L2 Pro platform, our goal is to spread awareness around IPR. Today's webinar is a very interesting one, where we all hear insights around industrial designs in India from our two distinguished speakers today. We'll introduce them in a short while. This series is brought to you by an IP course material called L2 Pro, which stands for Learn to Protect, Secure, and Maximize your intellectual property or your innovations. Just give me a minute to share my screen. Can somebody confirm if my screen is visible?
It is visible, sir. It is displayed.
Okay, great. Okay, so Learn to Protect is a platform which typically means learn to protect, secure, and maximize your innovations. Now, the idea or the inspiration to create this platform came from our experience with the startups. We have our startup program, in which we have worked with more than 150 startups in past few years. And we have seen that there are a lot of startups who are pretty good at managing their intellectual property, while there are other startups who need mentorship to reach where they are today. So with that insight in mind, we try to create a platform with the goal, with the collaboration with Department of Industrial Policy and Internal Trade, DPIIT, and CPAM. The content is created by NLU Delhi. And the goal was to align with the government policies of Startup India and Make in India. Right? The course basically is designed to educate startups, micro and small, medium enterprises, and basically any innovators, whether it's from academia or anywhere, to educate them about intellectual property. This platform is created to help the learner to have a better understanding of intellectual property domain in general, right? Covering concepts like how to protect innovations with patents, how to use copyrights to protect your software, what's the role of trademarks for a company, right? What are the considerations that startup should have in order to manage IP, or in other words, how to build an IP strategy, right? So this course is designed to give a holistic understanding of IP as a tool, as an industrial tool, and to integrate into a strategy of an organization and benefit from it. This course has been divided into 3 levels. The first one is the basic level, wherein the fundamentals around intellectual property is covered. So it covers, it provides a general introduction on patents, trademarks, geographical indications, etc. All right. The next level basically is to cover a little bit advanced level concepts of intellectual property in terms of how do you create non-disclosure agreements, how do you think about IP commercialization in terms of assignments and licensing of IP, and so on and so forth. The third level, which is the advanced level, covers details around accessing funding through the venture capitals, and various other means. Also, it deals with the concepts around standards and standard setting organizations, and how does the standard work, and how the intellectual property in that context can be managed with. And also it covers managing disputes like infringement, the validity and defenses of the infringement, and also means of solving those disputes like arbitration, etc. So in general, all these three levels gives a complete understanding around how IP strategy can be built and how IP can be effectively used for an organization, whether it's a startup, whether it's an academic institute, or basically it's an independent inventor. The course is designed not just to cover the fundamentals, but also to give practical insights through case studies.
Yes, ma'am.
So you will see that there are interesting case studies in the course.
Ma'am, have you registered
And,
on that link?
wherein you are prompted.
Okay, ma'am, when did you
given a
register?
scenario
Because
and
you
prompted a
sent it
question in
quite
terms of
several
what
times.
would you do.
You have WhatsApp on this number, right?
Let me mute your video. Audio.
Sorry, can you please mute if you're speaking? So basically through the case studies, this gives you a practical insight into how intellectual property can be managed and used. Now, these are some screenshots from our L2 Pro app, which is available on the Play Store, and it's freely available. Anyone can download it, register it, and start accessing the course material. The app is designed in a very to be very interactive, and gives you enough opportunity to digest the course material, right? There are some insights like who are the patent facilitators whom you can access for creating your intellectual property assets. Things like what are the schemes that are being offered under startup schemes that could be beneficial to you. There are also some pop-up questions for that test your understanding and see if you are able to get the essence of the intellectual property and its concepts. There's also a website version of it, so you could access it through l2proindia.com as well. And again, the same way you could access different modules of this course through this website as well. And it also offers you various concepts and pop-up questions and things like that. There is a free certification if you attend all the questions, and if you go through the certification, then you get a certificate which is co-certified by CPAM, NLU Delhi, and Qualcomm. And basically, at the end of this course, you will have a good understanding of how you could, what's intellectual property, what are the basic concepts around it, and how you could build an intellectual property strategy which can be part of your organization's overall strategy, and you could take benefit out of it. We hope that this course will give you this understanding, and you'll be able to benefit from it. Now with that, I would basically like to introduce our first speaker and move to our next segment. Our first distinguished speaker is Sri Jayaveerji, who is working as an assistant controller of patents and design at the Intellectual Property Office, Delhi, since 2016. Prior to this, he worked as assistant professor in Department of Textile of Dr. B.R. Ambedkar National Institute of Technology, NIT Jalandhar, and as assistant professor in Fashion Technology Department of BPS Women University in Sonipat, Haryana from 2014 to 2016. He has also worked as shift engineer at Benlon India Limited, New Delhi. He holds an MTech degree in textile engineering and a BTech degree in textile technology. He was also part of Indian delegation in 28th meeting of International Authorities, WIPO, Geneva. He was part of an Indian delegation for PCT quality subgroup meeting of WIPO, Geneva in 2021. and also part of Indian delegation for training programs by Copenhagen Business School, Denmark, under the MOU between DPIIT and Danish Patent and Trademark Office in 2022. He also has published 5 papers in journals and conferences. It's an honor and privilege to welcome you, Sri Jaivirji. Welcome to this webinar. Our second distinguished speaker, Professor Rajat Agarwal, is DPIIT IPR Chair Professor, Department of Management Studies, Joint Faculty, Department of Design Institute at Institute of Technology, Roorkee. Dr. Agarwal is recipient of Ramkumar Prize for Outstanding Teaching at Research at IIT Roorkee. Is a professor at Department of Management Studies and also the DPIIT IPR Chair Professor at Indian Institute of Technology, Roorkee. He was Associate Dean for Innovation and Incubation Center at IIT Roorkee. He initiated the process of establishing the Design Innovation Center at IIT Roorkee and presently coordinator at the center. Dr. Rajat was a visiting fellow to Copenhagen Business School, Denmark. He is Janida Fellow from Government of Denmark and also alumnus of APIC Japan Patent Office. He was awarded ICCR Chair at Indonesia in year 2016-17. He has more than 140 research papers in research journals and more than 25 research papers in revered conferences proceedings. He is widely invited to organize MDPs, address conferences, and training programs as main key speaker. It's an honor and privilege to welcome you, Dr. Agarwal. With that, I would hand over to Sri Jaivirji to share his insights around design and its protection.
Sir, is my PPT visible to you?
Yes, it's visible.
Yeah. Yes. Before starting, first good evening to everyone, and it's really good to see KSOCM organizing such events for targeting MSMEs and startups. That is very highly needed in this in our country because of awareness and training purpose. And good evening, Rajat sir, for attending the program, and also SOCM and team, and also Nitin Sharma sir for giving me an opportunity to give the presentation on registration of process of industrial design. Now I start with my presentation. Is it visible in slideshow mode, sir?
Yes, it is visible. Please.
So before going into design registration part, I would like to little bit highlight about IP administration in India. IPRs are administered by, most of the IPRs are administered by DPIIT, Department for Promotion of Industry and Internal Trade. They include, under which there is a office, that is the Control Journal of Patent, Design and Trademarks Office, that administered by different divisional offices or offices. Patent Acts 1970 administered by this authority, and Trademark Acts, Copyright Act, Semiconductor Act, GI Act, and Design Act of 2002. There are also some other IPR that are administered by other offices or ministries. like Plant Protection of Plant Varieties and Farmer Rights Act. That is the in US part of patent itself, but here it is administered by different authorities. That's the Department of Agriculture and Cooperation under Ministry of Agriculture. And Biodiversity Act that touches upon intellectual property rights is also administered by Ministry of Environment and Forest. Now, why register your design? And that would be, I think, a little bit to highlight about this. First important thing ki this gives you exclusive right to apply your design to your article made to make you this article and sold in the market. Exclusive route is provided for 10 years and extendable up to 5 years. Second thing, you have a unique selling point, calling point. You can sell it, unique selling point. You have a new idea of design. You can sell your customers, and that increase your competitive edge also, market advantage and competitive edge. You can compete when you have something new, so you can compete your competitors. You certainly will have competitive edge over your competitors. And last important thing, because of 10 years protection plus 5 years protection, you can enjoy your exclusive right. Now, what is a design? According to our Design Act of 2000, design is what is a design? Design is something that is aesthetic aspects or onward appearance. Outward appearance is our only design. It's only about, you can say, outward appearance. It's not about functional requirements and other things, but it's about aesthetic aspect or outward appearance only. And it is applied, the second condition, it should be applied on article. That article may be in 2D form or 3D form or both forms, combination of both. And by industry, this article should be applied by industrial process or means. Industrial process here, industrial process means something vast is covered here. So not about just a limited industry. It includes also the industry, agriculture sector as industrial process innovation. And both by combining an article on that the aesthetic aspect on article through industrial process, the finished article should appeal to eyes or solely judged by eyes. It should give some appeal to eyes. So it is this is known as, according to our act, it design. Now, what is not a design? There may be some designs, but they are not considered design under the Design Act 2001. Any mode or principle of construction, because this is something functional part that can be covered under Patents Act or any other and Patents Act or Trade Secret Act, other. So you can check that is not part of design. If anything, mode of, like you making something, and so you have to only for design, you have to only look for the aesthetic aspect only, not for their construction part and other part. Mere a mechanical device, you are not making any design aspects in that. And trademark property right, trademark and trademark act property right under Indian Penal Code Act or now changed act. Aesthetic work, you can say aesthetic work, like they are already covered under copyright, so they are not. There's a very fine line between aesthetic work covered under design sometimes and under copyright by courts established recent time. Now, what should be the aesthetic aspects of outward appearance? These are maybe the features of a shape, like you are making a change in the shape of any particular item and article. And second, about configuration, you are changing pattern, you have different pattern, ornamentation you are making. And now ornamentation and painting sometimes confusing, but there is also a fine line between ornamentation you making and painting, you are under copyright, covered under copyright. Composition of lines and colors. So these are the some things. Now, by industrial process, as I earlier told, that is the vast term that may be manual like handicrafts, mechanical, chemical, separate or combined ones. Now, some like you see the pictures of like 2D. If you say the 2D pictures like a fabric on fabric, the combination of different lines we are saying and other designs, that is the 2D form. And Ganesha's photo we see that is the 3D. So this type of designs you can go for registration in India. Now, registrable designs. Sometimes it may be designs whether it is registrable or whether it can be registered in India or not. Design cannot be registered, or you can say can be registered only if is it new or original. Okay, new or original should be. New means something that is entirely made right now. Original means sometimes like Taj Mahal was already known and you are making something design on Taj Mahal and in other form a little bit that by changing something, or that is maybe the original category. Now, second thing, a design should not be publicly disclosed by publication. That may be prior use, even a YouTube video may be also there. So not only publication doesn't mean only on paper publication. That may be other form of publication also. From the prior to the date of filing date or prior to date. Filing date and prior in India, generally, if you file an application in India only, then that is the filing date is prior to date itself. But when someone files in other country, then comes through convention route in India, that is not known as a prior to date. Design should be significantly distinguishable from non-designs and combination of non-designs. It should be significantly distinguishable. Like sometimes it happens ki you have a design that has some combination of lines and combination of colors. Now what happens ki the combination of colors is known by some, it already known by design, same combination of color, and same combination of lines is known by other design. Then the controller will see whether both non-designs can combine or not, or whether it is design is can be registered or not in the act. It should not comprise any scandalous or obscene matter or morality related issues. And last, it should not be prejudice to interest of security of India. Under this, most of the comes like defense related designs you are covering, like rocket design you are covering. So these things are required some permissions and all other things. Now, in short, designs are given for shape, configuration, pattern, ornament, component of lines, colors applied to an article, maybe two-dimensional or three-dimensional or both. It should be new and original, significantly distinguishable from non-designs. It should give some appeal to eyes or solid by eyes. Like appeal to eyes, how can give like a simple ice cubes you will have. This is not giving an appeal, but when you're changing it in a form of heart, it gives some appeal to eye. So that can be this sort. This is just for example. I'm not going whether it is can be registered or not, whether it subject to meeting other conditions. This giving some appeals to eye. Now, design acts designs are administered under Design Act 2000 and Rule of Design Rule 2001, amended 4 or 5 times since then. This is the combination of lines you can see, and there may be next a toy that is the three-dimensional design and is giving the appeal because it's simple toy, and then you have a toy that a different color of nose, big nose and big ears like this. So that is give some instant appeal to the eyes. This is a combination of again lines, a line we are playing this also design, a ring you can say, a different design. So these are under cover, can be covered under design. Some examples of designs you can see like mobile phone is a classical example. It includes almost all IPRs, intellectual property rights. Like design, only design aspect you see, so like design may be different. Sometimes even concave type mirror, convex type mirror, without if they do not involve any functional requirements in it. Decorative articles may be. Okay, and like nice set. There's sometimes a design can cover set of the articles like cup set you can say, or like furniture set you can. So this is the set. And now consumer part, pharmaceutical part, textile jewelry, even foodstuffs can also be designed. Like you have an apple, then you cut the apple in a definite shape, and then you can sell it in market individually in different ways separately, and that can also be think of a design subject to meeting other conditions. Type of design applications, generally two type: ordinary applications, like ordinary application you directly file an application in our country, that ordinary application. Reciprocity application outside some foreign applicant, even Indian applicant in foreign country, they can find a reciprocity application that claims priority of application filed in their own country. So that should be generally filed. That should be filed within 6 months from date of filing. Now, some important documents that required for design we are coming like Important forms. One is a form 1, that's the application review form. So there's this webinar is emphasized on the requirement of SMEs and startups. Government has taken care of it already, and there's 75% reduction in fees for startups, individual, and even small entities. Only 1,000 rupees fees is chargeable. And you have to inform when you have to provide applicant's name, nationality, address of service. Address of service is necessary when foreigner making in India. So they generally can give the address of patent agent also. Class number, they are around under the Locarno agreement. There are 32 classes, so class number should be mentioned. Subclass article and name of the article, signature of the applicant, authorized person with date, and all these things you have to provide. Even assignment, if you are using you have the design of other person. Now authors, representation, this is the important thing. Representation form, you inform you have to representation matlab aapko, you have to provide images in a form that can give all side representations of your article, all views, as much as views you can cover, give it to the application, because it will be easy to decide the application by the examiner controller. And it should be given in A4 size durable paper. Nowadays you can file on online also. Seat number to be mentioned, each seat to right hand corners, best quality photos you have to provide, even computer graphics you have to provide. You can also view even some top of models, but only if asked by controller, exceptionally you can provide them. Name of view, side view, top view, bottom view, all are used names you should identify. Name of applicant on the top. These are some formal requirements where should be the name of applicant, so that a uniform should be mentioned for the all type of design applications. Statement of novelty and disclaimer, you have to provide. That disclaimers sort of says ki you are not covering any trademark related cover, even functional requirements. So this disclaimer is must. Signature and authorized person's sign should be there. And yeah, again, disclaimer stating the mechanical part, that is part of disclaimer. Both are disclaimer. And if you are filing through a patent agent, in that case it is mandatory you file power of the authority in the favor of the applicant. And form 24 is required because we are dealing with small, the webinar is dealing with startup and small entity. In that case, when you are availing the fees relaxation, so form 24 should be given along with evidence. Like for MSMEs you have to provide Udyog Aadhaar registration certificate, and for startups DPID certificate, subject to condition that is both are document valid one on the date of filing. And next, I am coming design application, general process. What is the filing of the application? Then the office provides some date and application number. It is examined, and if no objection, then the application accepted. If there's objection, then communication FER, first examination report we call it. It is sent to the applicant or authorized agent. He have to comply within a prescribed period from 6 months from filing. To objections, if he has not, in that case, the application will be withdrawn, considered withdrawn. If a hearing will be given, or if hearing is contested, in that case either it is accepted or refused. After refusal or even after the abolishment of the IPAB, you can appeal to High Court. And on the direction of High Court, we can either be accepted or rejected, whatever the case may be. Now, certain benefits extended by the office or even DPIIT government to the startup and SME regarding design registration. First is the fee concession is given 75% to MSME and startup. 75% fee concession, only 1,000 rupees for filing. Second important part is scheme for facilitating startups intellectual property protection scheme. So this scheme, startups can file. This was especially for startups. Afterwards, it was extended to some other category of applicants, but with some tweak in the case. Now, what is the SIPP scheme? Like startups, they can directly select a facilitator. Facilitators are the registered patent agent, trademark agent, or other bodies with the office of the CGPD team for this purpose. So there are around 2,500 such facilitators registered with office. You can contact them and file your application through them. They will draft your application, file, process before the controller, and all fees, professional fees, will be reimbursed to the facilitator by Government of India. I want to emphasize that this is about only professional fees. Statutory fees you have to pay. Statutory fees, that is requirement of government fees, like filing fees, you have to pay differently, but only part of professional fees, that is the significant part sometimes maybe. So that is reimbursed by the office of the CGPRD. And the registered patent agent and trademark agent, they are also fees in payable two stages, generally filing and disposal stage, and opposition matters may there is there is no opposition scheme in design, and there is a direct conciliation that is also after registration, but for patent and trademark there is opposition matters. And second thing, after sometimes it was extended to innovators and creators. Generally innovators and creators are individuals. So individual person, it was extended to individuals if they file their application through TISC, Technology and Innovation Service Centers, that established by WIPO and Government of India. There are around many technology centers established recently, and 20 technology TISC has been approved. So this file TISC and then select a facilitator. Accordingly, the same process you can follow. But in 2023, this education, 2023 or 4, this educational institution also been included in this. If education institute go to TISC, in that case, their facilitation can also be filed. This is SIP scheme available in case of not for all IPR, for patent, trademark, and design. Thank you. This is all about the process. Any query you can.
Thank you, Jaiveer. I think this was very insightful and definitely gives a clear idea about the registration process and, more importantly, the facilitators and the incentives provided by the government. So we do have a couple of questions, so maybe we can quickly take those. So first one is, do we have to file physical copies of our design applications?
No, sir. Now you can file online also. If you want to file for physical copy, then you can file now.
Okay. I hope that answers the question. The next one is, what are the two sets of representation sheets?
Two sets of now in online, this is not issue, but on that time it was required in online 2 sets of means 4 copies we needed. But after that we need 2 copies. 1 copy was that on that marking was made, and sometimes they make a polybag type apply on that. So 1 copy we needed that is clear enough so that we can scan it and upload on data. That's why we needed 2 sets of copy on that time.
Okay. The next one is, I have modified a machine for special purpose. Can I file a design patent for the same?
No, design again. I think sometimes you get confused with US system. Design patent we are not following. We have only design system. Now machine, you are saying that machine you have only modified its design. That is not involve any functional requirement. In that case, subject to other condition, if you that is the new original and meets other condition, then obviously you can file, no issue.
Okay. Is e-sign digital signature required for filing?
Yeah, there is requirement of digital sign or e-sign for
that. Can registered design be amended or modified after registration? If so, what is the procedure?
After registration, design can be registered. Cancellation request can be filed, but registration part, I'm not sure whether it can be or not. I can check and confirm to you shortly.
Okay.
Sometime, yeah.
Sure. I think the one last question that we take before the next presentation, can we file 3D CAD file of a design as online filing? Is it possible?
Sorry, computer, what you are saying, I could not get you. 3D file, what you are saying?
So I think the question is that if we have a CAD file, the computer-aided design file, which gives a 3D
that
view
is a part of copyright, I think, right now. So we should not, because it should be like a process. You are showing CAD, that is only computer only. That is not now a product or article according to the.
Yeah, but I guess if the design is represented using a CAD file, do you think
in that case it can be? Yeah.
Oh, okay. So I think the answer is like yes, you could upload a CAD design, but then
graphics I have written, so that includes, I think, CAD also.
Okay, sure. Okay, so I think we do have a few more questions that are coming up, but let's probably move on to the next presentation before we take up the other questions. So, Professor Rajat Agarwal, would we like to invite you for your talk, and looking forward to hear from you. So over to you, sir.
Thank you, Nitinji. I was listening to Mr. Javeer's talk, and good to know that he also participated in a course of CBS Copenhagen, where I also went last year. Good. So, very good afternoon to all of you and all the panelist members, Kirti, Parul. I hope there are about 100 plus attendees attending this particular session at the moment. So, Javeerji was talking about all the legal aspects of design registration in our country, that what are the nitty-gritties of design registration. And in fact, the last point which he was mentioning about a very interesting term. In my campus also, a large number of faculty members used to say about we have got a design patent. So the kind of terminology which is popular, that design patent people, and then when you add the word patent with design, we start looking for functionality in that also. While technically speaking, as per the act, it is simply the look, aesthetics, which is to be protected, not the functionality. So this is a very common myth whenever we are trying to go for design registration. So I will not be talking of the legal aspects, but more from the business point, that why should we go for design registration and these things. So let me share my screen, and I hope my PPT is visible to you.
Yes, sir, it's visible. Yeah, please go.
And whether it is
I think it's in the presenters mode, but I think
yeah, let me swap it.
Yeah, I think it works now. Great.
Yes. So okay, there were some examples given by Javeerji also in his presentation. So let me start with, I hope all my attendees can easily identify this product. Can somebody tell what is this product? No, it's mobile. Yes. So it's a Apple iPhone. Similarly, if we talk of this product, Nataraj. Good, fantastic. Then this design, Maruti 800. Yes, that's more precise. Now coming to these products, Fanta, Coke, Tube. So in fact, as now we can understand that there are different ways through which you can create your own identity. And one very popular way of creating the identity is trademarks. But just by visual appearance, if you can create the identity, this is another strong way for which business may look, that how our products can be created with some kind of unique identity. And that's the very basic purpose of registration of industrial designs, for creating unique identity, so that in a competitive market, customers can easily identify the product because of your unique shapes. So we already know that what is design, particularly design which is registrable. So this is a kind of visible shape which includes configuration, patterns, ornament. It may be a two-dimensional, three-dimensional shape also. All these things can be the protected under the Design Act, as it was mentioned. And there are large number of lists as per Indian Design Act, which is not registrable under the design. which can include like stamps, maps, books, and so on, labels, tokens, cards, principles or method of structure, construction of an article, processes, etc. Then buildings, structures, parts of article not manufactured and sold separately. So all that is the list of items which cannot be registered. Then there are different types of treaties which have taken place over a period of time for developing the concept of design registration. It started with the Paris Convention for the Protection of Industrial Property way back in 1883. Then latest, we all use this Locarno Agreement for international classification of industrial design. We will be talking about this Locarno Agreement, that how 32 different types of product categories are identified through which you can classify your products. So this is a long list of 32. Very interesting is the first itself, where you are able to protect foodstuffs and biscuits, cakes, all these types of items can also be having the design protections. And so on, you can see that textile goods, fashion goods, they are also possible to be protected under the design systems. Then there are transportation items, recording devices, photographic, cinematographic items, musical instruments, printing machineries, stationaries, then medical equipments, tobacco, smokers supplies, then machine appliances, graphic symbols, logos, surface patterns. All these are the different types of classes. And then every class has a long list of subclasses also. So it's not only main classes, but subclasses are also there, which are mentioned under this Locarno classification for registration of your goods. Now, why we should register the design, particularly from the business point of view? Because of your unique design, you are able to attract the customers for your products. Because of unique design of Apple, because of unique designs of Mercedes, because of unique designs of Audi, you are able to create that identity among the customers, that customer can easily identify your products. You can be identified with the help of your trademarks also, but design also supports in creating a identity for the products. So sometimes the attractive designs also become a source of USP for your products, and that is the one important reason for the registration of design in the business. Then because of superior designs, because of innovative designs, it may affect customer choices also. Customer may like to have a product where the design is creating some kind of attractiveness. Then design is also significant for SMEs, and not only SMEs, I will say for startups also, because startups always look something very unique for their products. And when they are competing with large companies, the design may help you, because it takes long amount of time, very long amount of time to build your brand trademark. So customers may easily be attracted towards your product as a startup because of your unique designs. So designs help in getting a initial market attraction for startups, SMEs, as well as for large companies also. Whenever they are able to create a long set of product mix, so a similar kind of designs help to create a customer is very easily able to associate your products with your company's name. So like in case of iPhones and Mercedes, I say these are the large companies, but they have a similar kind of design patterns almost for all their products. So you can see unique types of curves which iPhones are using. So whether it is iPhone or iPads or any other Apple products, so the curves are almost of the similar type, that creates a unique identity for entire product family of Apple. Same is the case with the Mercedes also, whether it is SUV or a passenger car, they have a similar type of product categories, and that will help Mercedes to create a unique identity for themselves. So that is also a type of benefit for large organizations as well as for small organizations where they don't have any brand as for them, and they are able to get the market because of their unique designs. Then it is always also very important that you need to be first to file principle which is applicable almost in all kinds of IPR activities, whether it is a patent, whether it is a design. So you can only take the benefit of industrial design when you are following this first to file rule, because we will be discussing with the help of some interesting cases in our country that how some of the companies could not take the benefit because they did not follow the principle of first to file. So that is very important, that as soon as you bring a new type of design into the market, you should immediately go for filing of that design, registration of that design. And if you see this particular data here, we have taken this data from the annual report of our patent office, and this data suggests that how in design particular field, how Indian companies are doing much better than the foreign companies in our country. Otherwise, if you see the patent data, in patent data, unfortunately, in Indian patent office, more foreign filing is happening as compared to Indian filing. But in the case of design, this is a satisfying trend that we are having more applications coming from Indian applicants as compared to foreign. And here we have the full data with respect to different classes. So the class which we are following is the Locarno classification here. So as per that, in which category of products we are getting how many applications, that data we have taken from the IPR report of Government of India for 22-23. And here you can see that there are some specific classes in which you are getting more number of applications as compared to other applications. So these are we have separately classified, means put them into a slide so that all our attendees can understand that in which categories in India we are filing maximum number of design applications. So we are filing large number of applications in the field of clothing. So that is you will see that almost all the fashion designers in India, they are filing their new designs under the design registrations. Then another interesting area is transportation and hoisting. So large number of applications are coming in that area also. Uh, Probably this is because of good amount of infrastructure development happening in our country, and as a result of that, large number of applications are coming in that infrastructure sector. So we are getting good applications in that area also. Then another is fluid distribution equipments, which is more related to irrigation point of things. So various efficient irrigation devices are coming. So their protection is also happening in our country in a good number of way. Then packages and containers for the transport or handling of goods. So container and packaging, that is fourth important area in which design registrations are happening. And there are significant progress, and I don't have the data at the moment on my slide, but I saw this significant increase in medical laboratory equipments post COVID coming from India. So if I have if you compare the data of this class 24, which is for medical and laboratory equipments, our filing were very less pre COVID, but there are significant increase in this category also in post COVID in India. So that is the kind of data which I think may be very useful for all our participants, that in these areas, India is doing very well with respect to design registration. Then you see the trend of registration over a period of time in India, that how now almost all Indian companies, educational institutions, large companies, SMEs, etc., have understood the importance of design registrations. And you see this number, that the thread which is at the lowest level, that is the foreign filing in India, and then the blue thread is representing the Indian filing of the designs in India. And you can see that there is a continuous increase from 2018 to 2023. There is a continuous increase in filing in India from 8,864 to 18,170, and overall number is also increasing. There is a slight, you can say, change in pattern from 21-22 to 22-23, that Indian filing has slightly decreased and foreign filing has slightly increased, but there is a huge gap between Indian and foreign filing in these 2 years also. So that is itself indicating that Indian business is understood the importance of design filing, and that's why there is an increased traction in design filing in India now case. You can have another interesting data which is coming from different states in India, and you see the states which are considered to be highly industrialized states. For example, Maharashtra, Gujarat, etc. You have maximum design filing coming from these states, and this data is again taken from our IPR annual report. So that gives you the picture that how IP filing in different states are happening. The entire data is available in front of you. Some of the examples which we have taken from the IPR journal to give you that what type of information is available whenever you are submitting the design application. So I can skip this part to so that you can search on your own on the design journals. Every Friday there comes a journal from our patent office, and the last part of the journal contains the design applications. So we have taken some of these samples from the design journal. So you can see that different types of examples are there. Then just to highlight the importance of design registration, we have also taken some of the very, you can say, prominent cases which have happened in our country in last few years. This is a case of Cello versus Moodware. So Cello has filed this case alleging the company Moodware that they have copied their design. So if you see on your screen, you can see that the designs of Cello as well as design of Moodware, they have created a brand name Kudos. So that Kudos design is almost similar to Cello's design, and this case went to Bombay High Court. And if you can just a minute, just a second. So this Bombay High Court was of the view that the product and design must be seen as a whole from the perspective of the common consumer, and they said that yes, it appears to be a copied design of Cello, and the decision was given in the favor of Cello, and some kind of damages were also awarded to Cello. So the amount of damage is not in the public domain. So that figure I cannot give you, but in the because of the design protection, Cello could get this kind of relief from the court. Similarly, there is another case. Now, this is another very interesting thing that Crocs, which I think many of us may be aware, is a very popular footwear brand. So, Crocs filed a case against a consortium of Bata, Liberty, Relaxo, and Action. And Crocs said that all of them are infringing the registered design related to perforated and non-perforated footwear designs of Crocs. And Crocs said that they are the owner of this particular design, and these are the all these parties are infringing the design of Crocs. So the issue was discussed, and after the detailed discussion, it was found that Crocs registration was faulty, and they said that means the design which Crocs registered was already in the public domain. So there was did not get any kind of relief from the court. So the point which I was saying, that first file principle was very important. The design was already in the public domain in 2002 in USA, and registration was done in 2004. So the benefit of design registration could not be availed by Crocs, and they did not get any relief from. So these are the, you can say, all those designs about which Crocs were making the complaint. Then another case which is between two Indian companies, Kamdhenu, I think many of us may be aware, is a steel rod making company, and Ashiana rolling mills. They are so Kamdhenu versus Ashiana. So in this case also, the infringement of registered design pertaining to double rib pattern of steel rod, and the design that formed part of the registration was published as part of British ISO standards before filing date of the design application, and therefore the in fact in this case the Delhi High Court cancelled the registration without any need for the trial. So here the issue came that Kamdhenu was actually trying to allege sue Ashiana Rolling Mills, but ultimately it was decided that the registration given to Kamdhenu was not correct, and the registration was finally cancelled. Then another very interesting case happened between Troika Pharmaceuticals and ProLabs. This is about a design which they have started for making their medicines using D-shaped tablets, Troika Pharmaceuticals. And the same D-shaped tablets were also made by ProLabs, and therefore the case went to the court, and the ProLab was actually arguing that D is a very common symbol, common word, so it cannot be protected. It does not deserve the protection as the design protection. But court acknowledged that D is a very common design itself, but its application to pharmaceutical industry, particularly for a tablet design, is new and original, and therefore the court finally decided that the D-shaped design in tablets can be given to the Troika Pharmaceuticals under the Design Act. So though for many of us it may appear that what is so novel, what is so unique in D-shaped tablets, but by a proper understanding of Design Act and using the design for your advantage, you can see that how companies are able to protect their interest, and Troika's D-shaped design is now well protected under the Design Act of India. Relaxo footwear versus Aqualite India Limited. So that is another very popular case that both plaintiff and defendant are involved in footwear manufacturing. I hope most of us are very well familiar with these big brands. And plaintiff claims that the design of footwear defendant has launched is imitation of the registered design of Relaxo footwears. So now the issue is that whether the claim of plaintiff are on legitimate grounds, and whether there is a infringement of designs or not. So on the basis of two types of designs which are there on your screen, you can see that the court actually favored the court realized that yes, there was an infringement, and court favors the plaintiff. So that is again because of the proper design registration. Another similar cases happened between very two big names in India, Whirlpool and Videocon. You can see the design. Here also the court actually favored the plaintiff, and court held that the Videocon machine infringed Whirlpool's design, and that Videocon was passing off its machine as those of Whirlpool's. So that is how so many cases we see that because of appropriate design registrations, companies could protect their business interest. Because as a customer, sometimes we are misguided if two similar kind of designs are there in front of us, and these similar kind of designs create confusion for a customer who is not so well aware. So the misuse of our hard work of creating new novel designs can be avoided by proper design registration. And not only by registration, the enforcement is also equally important. If you do the design registration, but you are not vigilant enough for knowing the cases of infringing your design, then you will not be able to take the business benefit of your design. So not only designing new products, their registration, and after registration, their management, that through the life cycle of the design, the management of those designs, management of your IPR is equally important. Then only you can take the business benefit of these IPRs. If you are not able to do the entire cycle of IP management, probably the benefits will not be coming to you. So all these examples which I discussed, these companies could take the benefit because they were vigilant. They could see that there is infringement of their IP, and because of that, they went to court, and they actually fought well and got the benefits or proper relief from the courts. So that's how various organizations, different organizations like Nike's Air Jordan, they are also using design as a business tool. So you can see that that's a very popular case, not from India, but they are using their design registration for developing a business kind of advantage. The automobile is another very fantastic example, which is a highly design driven industry. You actually buy many new cars, new models, because the technology wise, the functionality wise, many vehicles are almost same, but customers prefer one design, one brand or one product over other, just because of the design. So that's a very interesting case. So in the case of this automobile industry, Mahindra, Mini Cooper, they have pioneered that how they are able to get customer attraction because of their superior designs. Companies like IKEA also, they are using design so successfully, they are able to attach that their designs are environmental sustainable. So now that type of perception has been embedded in customers' mind that IKEA designs mean sustainable products. So that kind of branding is also possible with the appropriate kind of designs. Then some kind of strategic benefits are there, like you are able to attract some kind of exclusivity because of your designs, and because of that exclusivity you may demand a kind of a premium pricing for your products also. So that type of benefits also possible with appropriate design registrations. So fashion industry, as we have already discussed, is one of the champion industry in India also, where a lot number of industrial designs are happening from our country. So in India, people are not so concerned about this design type of IP. Whenever we are talking of IP, generally the name of patent comes in our mind, because many of us keep patent and IPR as synonyms. We can use them interchangeable, but I feel that design can also be a good way of protecting your business interest, and at least for the appearance wise, design can be a very strong way, because design registration is much simpler as compared to getting a grant of the patent. So you can easily go for design registration. The fee is also much less as compared to patent registration. The process is also very simple. So therefore it is uh, I think need of the time that more and more Indians, they should go for design registration and see that how are they able to get more value from creating the novel, innovative designs, and with those designs they are able to get more benefits for their markets. So with this, I come to end of this presentation. Thank you very much, Nitin ji.
Thank you, Dr. Rajat. Amazing presentation. I think very beautifully highlighted the importance of business aspects in considering the filing of an IP, especially in this case, the design. I think we have covered two aspects of the IP. I think this is great example on how the IP can be created, which we discussed in the first presentation, and then the second aspect of after you have created the product, which is the IP, which is different from the product as such, right? On which the IP is applied, but IP as a product, how you create it using the design registration process, and then how do you make use of this product as a business tool, as a product in itself, right? So I think we have covered these two aspects of it. We do have some questions, so let's take them, and please type in your questions as we go. So the first question would be, can we protect a design using both industrial design as well as a copyright simultaneously?
See, both have slightly different scope. When you go for a product, in fact, you may require multiple type of IPs for protecting a particular product. When you are having a product, the kind of manual you create for that, kind of SOPs you create, the way you print your ingredients on the label of that product, all that can be easily protected as copyright. And the shape of your product, that is protected through industrial design. And then the functionality of your product can be protected by patent. And then the brand of your product can be protected by trademarks. So I think when we are talking at a commercial level, we need to have a portfolio of IP for protecting us with all possible ways. So you should have at appropriate stage of your product, appropriate IP should come, so that you can use that IP in the most effective manner in the life cycle of the product.
Thank you. I think great answer. I think you got your answer that you have an IP or you have a product, it can have different aspects, and therefore the various laws that we have in protecting IP can be used for protecting all aspects of our product, whether it's the technical idea, whether it's the design, whether it's something that can be protected under copyright. So the other question is, can design of different organization emblem can get registered? So
Can I emblem? So generally, as I understand, the emblems can be registered as trademarks. So all the organizations, they register their emblems as trademarks. So that's my understanding. Javeer ji can further give more clarity on this.
Yeah, about emblem, organization is it's little bit confusing. They may be government organizations. So like emblem under emblem act, these are all things are prohibited to use the emblem for copyright design trademark. Even our manual also says emblems are not cannot be protected in the register
So we cannot put them as a
for commercial purposes.
design. They cannot be protected as design.
yeah, and also I guess it probably also depends on what's the use of the
Exactly.
entity, right? Typically, trademarks are something that we put on all the products that comes out from a provider, a product or service provider, versus design could be restricted to a certain set of products, etc. So yeah, I think maybe that could not be another way to differentiate. But emblems, as Professor Rajat and JVG has said, that it's mainly under the trademark because that denotes where the information or the source is coming from. Okay, the next one is, since there is no expedited examination in designs, how fast is design registered? And can a small entity expect a faster registration?
So there's no expedite exemption provision for any category of applicant. As in case of patents, we have expedite exemption for SME startups. But in design, I think most of the applications get delayed because of formal issues. So it's up to applicant how fast they can correct their formal issues. Their design can be registered.
Thank you. The next one is, after filing for design registration, is it safe for a manufacturer to start selling as there is no publication of the application?
I think it should be taken by Rajat sir.
Yeah, so as soon as you file the application, like in all the IPRs, our novelty date is protected from the date of filing. So same is true in case of design also, and you will be properly protected even if your certificate is not available. So the benefits, the date starts from the date of filing. So you can go ahead with the means protection of your product.
Thank you. After filing for design, sorry, this one is covered. How jewelry design can be protected under IPR?
So jewelry designs are very well protected under the design.
Yes.
So the design very well take care of the jewelry design. So in fact, not only big companies, smaller companies also taking the benefit of. You see in our design journals, every edition you will find some of the jewelry designs which are coming from brands like Tanishq and other renowned brands which are there in our country. So they are continuously registering their designs under the Design Act.
What are the common mistakes that applicants should avoid during the registration process?
That I think Javeer ji will give better answer.
But first of thing, they should provide as far as for clear images. Sometimes they do not provide clear images. We have to object their objection. As I earlier mentioned, most of the issues really happen due to the formal objection. That is up to the generally applicant. Sometimes what applicant do, they do not file the power of attorney or authority in their favor. Again, you will give objection, we recruit. So as far as you will met your formal requirements, I think registration part is not a big issue. In that case, substantive issue is not not raised. In around 95, it is written in our manual also. Around 90% of applications are objected on formal issues. We provide clear and according to requirements, all things met. Sometimes they do not even give the name of the applicant on representation sheet. These things are very small things, but these matters a lot because of delay. Can cause the delay. This is the issue.
Okay. Next question is, how do we know if the designs exist before?
This is really up to them. There are many organizations. I think maybe organizations. Rajat sir can be involved with it. They do some search for commercial purposes, and they're also like Google is the best friend. I think they can be used in search. Even in India, they can use this these things.
So we actually have this challenge that we do not have very good databases of design as we have the good databases of patent. So we need to be basically more dependent on the commercial activities which are in the open domain. Maybe Google can be a possibility through which you can get. And generally, let me tell you that you actually need to see the industry in which you are applying. So generally the popular designs are those who are working in the similar industry. They are aware that what type of designs are already registered in that. We generally do not go from one industry to another industry. People in the industry, they create their own you can say system for getting this information that whether these types of designs are protected or not protected. But still, yes, it's a very challenging thing, and many a time, even just now, as we saw in my presentation, that some of the design registrations which are done by the patent office were cancelled by the courts because of some kind of similar designs were already there in the market before the registration was granted. So those challenges happen sometime because of some you can say database is not so well developed for design related activities.
I think that this is also up to applicants. Those are sometimes they do not want to register the design. At least they, if they do not want to register it and file the application, they should maintain their data in that form that can easily be retrieved by examiners and controllers. It would be easy.
Yes, it will be.
The issue after that they file the opposition or cancellation request. The design was already in public. But how easy you can show? Sometimes they show they have design on their website. In patent, I observed that their invention is on website, but there is no date written on it. So we cannot ascertain the date. Then how can you deny a patent on the basis of this? So these things happens. The dates should be the important. How they can publish their designs, whether they want to register or not, something different issue. But they should at least their property. They should collect and should be public domain easily so that they can be searched by examples.
There is another question on graphical user interfaces. GUIs says why GUIs are not registrable in India. So maybe Jaiveerji, if you have any thoughts on whether it will be registered or not.
I just can say they are not, so they are not. Nothing else.
Sure. There is also a question regarding requirement of physical copies of representation in the form.
It varies. Generally, we cannot say because according to when the rules amended, in that case, within 15 days you have to submit original copies. Like this.
Okay. The question is whether, I mean, there is there still requirement of physical copy or soft
It's
copy?
The question I'm saying.
Okay. I think then let's quickly go to nature-inspired patterns, examples, cellular arrangements within plant parts. Can it be covered under IPR sample design?
Sir, it should be cellular design. Can any person see with eyes? It's really difficult.
Yeah, I guess the answer would, yeah, as you rightly said, I think if it exists in the public domain, then it's not, right? Where it's, yeah. What can be the penalization for infringement and fraudulent activity of IPR? I think it's a pretty broad question, but
It's a all by the wisdom of respected judges of the court that what type of penalty they are going to give, the kind of losses they are able to assess, the kind of so it is means there is no standard answer to this. It can be simply a warning also, or it can be a huge compensation, because we have the cases where 100 crores, 200 crores, 300 crores kind of penalties were also imposed by courts for the violation of IPR related activities. So there are so many examples of variety of compensation, variety of penalties given by the respective courts. So it is but what I can say at this moment, that now our courts are also becoming quite empowered with respect to IPR issues. About 5 years back, 10 years back, before national IPR policy of 2016 we got IPR policy in India. So before that, our judiciary was also not so well prepared to handle the IP related matters. But now after 2016, like in Delhi High Court, Madras High Courts, Bombay High Courts, at least these high courts I know, there may be a couple of more, where we have separate IP benches. And because now there are IP benches happening in the courts, there are lawyers who are coming with specialization in IPR. So a good amount of IP related judicial, let's say, empowerment is happening in our country. And therefore, you may see in future also that more stringent punishments, more stricter penalties will be imposed for IP infringements.
brilliant. Yeah, thanks a lot. I think this is great. I think we are almost towards the end of our time today. But I think over a period of last hour and a half, I think we have heard about the importance of IP, right? And designs are one of the very important component of our IP portfolio, right? And through the examples, we have seen that how businesses have taken advantage of their design innovations to protect their business and ensure that their hard work around designs are not just taken away by somebody else, right? This has also demonstrated as an important business tool. It has also demonstrated that there is an economic value to this, right? So this underscores the importance of this tool. And in the first part of our talk, where Jaiveer has highlighted how do you go about protecting it? What are the things that you need to take care of it in order to create this IP asset? And both of this all together becomes an IP strategy for your protecting your design and commercializing your design. The value of these designs are also demonstrated by the compensation of infringement that we see, right? And that the question that came up around the what are the penalties for it? I think if you go around and look at each cases that Professor Rajat has shared, you will see that it is all a function of what is the business damage that happens because of the infringement, right? And that kind of also tells us that the economic value of the design that's get created. So all in all, great session, great discussion. I really thank you, Jaiveer, for highlighting the process and the nuances and the pitfalls in going about design registration, and Professor Rajat highlighting the business aspect of it, how you could make use of these assets that you would create, and how do you go about protecting these. So thanks again for sharing those insights. Very valuable. I have taken certain key takeaways from this, and I'm sure the participants have as well. If you have more questions, if you'd like to know more details about it, I encourage you to register and download the L2 Pro app or go to the L2 Pro India website and get some more details on all the aspects of intellectual property, the basic concepts, the how to go about it, and how to commercialize it, and how to build a great IP strategy. If you have more questions further, please reach out to ASSOCHAM, and we would be able to answer your questions offline as well. Thanks again for the great participation. We have a good number of participants. Hope it was valuable. And thanks again to the panelists, Dr. Rajat and Jaiveerji. It's really an honor to have you here today.
Thank you, Nitinji, for hosting so well this session. I'm sure that we could answer some of the questions, but because of the shortage of time, all questions could not be answered. So maybe Nitinji or others can answer those questions. Otherwise, I have given my email ID on the chat window also. So if any of the participants want to know more, she can approach us also.
Wonderful. Thanks again. With that, we'll sign off for today. And
Thank you, sir. Thank you.
have a great evening. Thank you.
Okay, bye-bye. Take care.